Let's take you live to this, the Competition Commission and Tribunal hosting its 16th annual Competition Law Conference.
While strongly deterring those agreements that seek to harm competition through, among others, administrative penalties. They'll also ensure that enforcement furthers the objective of promoting more inclusive growth through the participation of SMMEs and historically disadvantaged persons in the economy. Our experience over the last 12 months of participation in mergers and acquisitions the last 12 years. Our experience over the last 12 years of participation in mergers and acquisitions have yielded considerable learnings. Our obligation to look not only at the narrow competition grounds for whether a merger can or cannot be justified, but to look also at the public interest and to balance these two is central to South Africa's competition regime. The Act explicitly compels us to look at how a merger impacts on employment, on small and medium businesses, on black business, on regions and industries, our ability to compete in international markets, on the spread of ownership in the market, particularly that of black South Africans and workers. Over the years, we've negotiated with a number of companies in all manner of industries, from food and beverage, national retailers, miners, oil and gas companies, and financial services. And the settlement agreements which have come from these negotiations have created platforms for partnership between the South African government and social partners, protecting and creating jobs and driving investment in resilient, competitive supply chains and in fixed assets. So the market has said, can we get more certainty on what's expected? By February next year, or sooner depending on our work, I will publish regulations in terms of the Competition Act setting out a guide for how the DTIC works with merging parties to craft an appropriate set of public interest commitments. These regulations will serve as helpful models to the market on how both our shared public interest and that of shareholders can be enhanced during a merger. With these regulations, we hope to address many of the questions which merging parties have on how the DTIC participates in mergers and how a meaningful set of commitments can be shaped. In conclusion, complexity and the level of national ambition will give many more areas where competition policy can help the attainment of national goals. The President has spoken powerfully on the value of social compacting, of a broader partnership for growth, investment and jobs. Some of the settlement agreements reached during merger proceedings may be described as social compacts at the micro level. At the same time, some of the efforts to foster greater local industrial development needs to guard against collusive actions that undermines strong and dynamic competitive competition between firms. So it's to just navigate this complex terrain. Our goal with competition policy are ambitious. It's been described as ambitious. It's been sometimes criticized as ambitious. The level of ambition is set by the size of the challenge South Africa faces, by the reality in townships and workplaces, not by the ideas in our heads. In our level of ambition, though, we should always carefully calibrate implementation with capacity and build that capacity. And always recognize that as we reform, it is unavoidable to disturb vested interest. That the test is not whether every single economic interest is happy, but whether the authorities are effective and that we make progress on that journey that President Mandela set out so clearly, and a journey that young people in townships and in rural areas desperately need us to take with greater vigor, greater energy, and greater expeditiousness. It strikes me that the practice of the new competition framework being pioneered by the South African competition authorities, the Commission, the Tribunal, and the Competition Appeal Court, has at times moved faster than the conceptual and intellectual work that normally accompanies a paradigm shift. There is a real need for a competition institute that would galvanize more PhD work on the South African model of competition policy, secure greater case studies that show us from whether it is predation to excessive pricing to a merger settlement agreement, what the impact is on the public interest. Deepen the teaching of the new competition framework to officials within government departments, to other regulators, to officials in the competition authorities, to practitioners in the law firms in Sandton and elsewhere. And that's something that I think would be an endeavor that we should take forward collectively. I hope you can come tonight. I hope you've all been invited for the dinner. I should check that first from those who are paying the bills. Because I think at this changing of guard moment, it would be appropriate to thank those who have led the work and to welcome those who are going to be leading the work. Thank you very much.
Nkosi Mhlekazi obekekileyo umphathiswa wezoqoqosho nezokhuphiswano nezoshishino jikelele obekekileyo Ebrahim Patel